Daniel, 11D encourages research and development with the intention to get to some protectable invention or discovery. Okay. So the main categories of protection in that regard are patents, registered designs, and trademarks.
Okay.
Also copyright in software and other works of art, but it's not really relevant here. What's really relevant here is the copyright protection that you can get for software. Okay.
Just to backtrack slightly, and just to make it clear to the viewers, we're talking about something that you're inventing and that's registrable.
Yes.
What do you mean by that?
If you look at a patent protects a new concept. Now, it has to be new worldwide, and it protects the concept, whereas a registered design protects the look of the article, the appearance of the article. In other words, if you have a new shape of a cup or a new shape of a part of an engine, it's only the shape that's protected. On the other hand, the patent protects the whole concept of the invention.
And both would fall within the ambit of 11D?
Both would fall. That is what 11D says. The intention is to get to a protectable invention. Okay. But 11D does not allow you to deduct the actual expenses for the patent or the registered design. That would be a normal expense in the production of income. But 11D, the R&D...
Give me and the viewers an example of what you mean.
I mean, for example, if you patent a new device or a new part for a motor vehicle, okay, the actual cost that you pay the patent attorney to go and file the patent and obtain the patents for you internationally...
Which can be a big expense.
It can be a big expense, but that expense doesn't fall under 11D. It falls under normal expenses. Okay. 11D protects the R&D around that development for that new engine part that you'll come up with.
If you were to outsource certain functions, or the scientists, or the invention or inventor, for instance, the machinery or the facilities used by that person.
That's correct. Yeah.
Okay. Yeah. So that's what it would cover.
Yeah.
Anyway, but
you also get other types of statutory protection, but such as trademarks. So if you come up with a brand name and you register the brand name as a trademark, but the trademark is specifically excluded from 11D. Okay, so you can only do R&D relating to, or with the intention to eventually get to a patentable invention or to an invention that can be registered as a design.
Okay.
Okay.
So trademarks and copyrights. We haven't discussed copyrights. Would copyrights also be excluded?
No, copyrights not excluded. So if you, for example, invent or draft or write a new software program, then you will have copyright in that software program, and the copyright will subsist automatically, and that also falls within 11D.
Now, just looking at copyright for a second and bring it within the context of 11D, what would you be entitled to deduct there? Because again, the registration costs wouldn't be deductible for hiring the services of the firm to assist you with protecting that copyright. That would obviously be the cost of the development of your software engineers and that type of developmental cost which creates this new innovation.
You must just remember, copyright is not registrable. Okay, so copyright subsists. Yeah, it subsists automatically. So if you have a patent or a registered design, you will go to your patent attorney, and he will then file the registered design for you, and you pay him for that. Okay.
Okay.
So, but those costs are not deductible under 11D. The cost to get to the actual software program and the actual R&D relating to the invention and the software, that falls under 11D.
Thank you very much for that insightful information. We're going to continue with this interview next week. For those of you who would like to read a little bit more about the interview, please look out for the next edition of Tax Talk magazine. Copies can be obtained on 011 476 5048. Until next time, goodbye.